All right, we seem to have leveled off on the amount of participants joining in. Hi, everybody. I'm Steve Zykowitz. I'm the branch manager for Fidelity National Title Insurance Company in Garden City and Riverhead, New York. We're really happy we could provide these CLEs via Zoom under the COVID-19 restrictions, and hope everybody and their families and their extended families and coworkers are safe and healthy at this time. We're very excited about today's presentation. We have a great speaker, and I'll just take a minute to introduce him. Actively at the helm of the law firm he built from scratch, Adam Leitman Bailey practices residential and commercial real estate law. Among New York's most successful and prominent real estate attorneys, Adam Leitman Bailey is one of two attorneys from a law firm with less than 30 attorneys that has been ranked in chambers, honored with a Martindale-Hubbell AV preeminent rating, a best lawyers ranking for himself and his law firm, and the Commercial Observer named him as one of New York's most powerful real estate attorneys. The New York Times referred to his legal strategy and legislation proposed in one case as novel, in addition to remarking on another case in which Adam Leitman Bailey fought on, grinding through excruciating detail and obscure Perry Mason moments. After Mr. Bailey's firm used a forgotten statute to prevail in a landmark case, the Wall Street Journal quoted a prominent developer's attorney who called the holding a game changer, affecting real estate nationwide. So without further ado, I'd like to introduce Adam Leitman Bailey. Please be advised that three number codes are going to be given out throughout the seminar. You have to fill out the forms that Amanda Muller has emailed to everybody. Without further ado, thank you and welcome Adam Leitman Bailey.
Thank you so much, Stephen. It's an honor to be presenting today. I've been in the Fidelity family, representing them and working with them for 18 years now. And it's a very special relationship because they were the first Fortune, 500 company that took a shot on me when no one had ever heard of me. And it's very hard for a Fortune 500 company to take a shot on a non-big firm and a firm that, is so small. So I hats off to Fidelity, and I will always have a weak spot in my heart for them. I feel very honored today to be able to speak to you. Number one, I think I am honored as a real estate attorney where we are so important today and we have the ability to affect change and really, for the first time in our lives, more than ever in history, help New York and America. So let's go to it. This lecture and these slides are changing every hour and every day, and we have to redo these literally every 24 hours because of the what's been changing. And let's see how we've done. Okay, let's get to it. Thank you very much for tuning in, and thank you, Stephen, for the very nice words of presentation. Late fees. Let me move this. What's interesting about, so what's going on? Very recently, less than 2 years ago, the legislature allowed the governor to become a dictator. I mean, that's an exaggeration, but allowed the governor to, in an executive order, supplement the law and change the law, but only for 30 days. Now, the governor hasn't exactly followed that. He's gone over that, but he can only do it for 30 days. Now, for this late fee, no late fee can be charged from March 20th to August 20th, 2020. The interesting thing about this is it's not permanent. So all these late fees that can't be charged on August 21st, you'll apply the late fees that weren't applied before. So the good news about this is you can collect your late fees, but do not charge them during this time. Do not have your clients charge them during this time, because if you do, you're going to have a problem. And That's it. I mean, knowing the laws and knowing how to advise your clients are going to help you a lot and prevent a lot of litigation. I'm starting out with the easy stuff first before we get into the really controversial, ease into it. Okay. Security deposits. This gets a little bit more complicated. Okay. The executive order on this says that tenants, residential, and we're covering residential today, residential tenants can ask their landlords to apply the security deposit as rent. Fine, good. Landlords are getting paid. But they have to pay it back. And they have to pay it back over 12 months. Well, the executive order can only go 30 days. We're going to get in a little further into why that's based on a decision, why that's more interesting. Now, this is good law, but as of today, the only people that can apply for this as of right now are tenants that are eligible for unemployment insurance or benefits under state or federal law, or my Bayside Queens accent's coming out, or are otherwise facing financial hardship due to COVID-19 pandemic. So the law first comes out in March, and it's covering everybody. Now it's modified whereby you could only apply your security deposit if you're on unemployment or you're facing financial hardship under COVID-19. I mean, isn't everyone facing some kind of hardship under COVID-19? Well, not Amazon, not not a lot of companies. Some of them are watching today, but or listening today and watching today. But but you're seeing where this is going as we go along. It's a lot of the laws are less and less in application. So how does this apply? The tenant has to pay this back over 12 months. So every month that goes by, they have to repay this, 1/12 of the security deposit that they paid. By the way, you can ask me questions via your chat session, and then Fidelity is going to send those to me, and I'd rather answer them on the spot. And we may not have time at the end, but if we do, we'll do that as well. Tenants must replenish their security deposit in monthly installments equal to 1/12 of the amount so applied, with payments commencing no less than 90 days after the date of such application. Alternatively, such tenants may elect to retain insurance that provides such relief for the landlord in lieu of the monthly security deposit replenishment, and requires landlord to accept such insurance. No one's doing that. We haven't seen that once, and we're dealing with 10,000 residential buildings. The New York City Guarantee Law. Now, this is commercial, but very few people know that. A lot of people are having a lot of confusion, so we're throwing it in this lecture. On May 27th, the New York City Council, in its infinite wisdom, defying the law, defying the United States Supreme Court constitutionality, and I'll go into why, puts in this law. But worse than this law is the perception of this law. And let me go into it. You can read the screen yourself. I'm not going to go into reading it. But what this does is it says permanently from March through September 30th, you cannot go after a guarantor permanently for rent for 5 categories. Now, this does not bar landlords from suing guarantors for rent and other financial obligations that arose either before or after the COVID period, meaning, before March 7th or after September 30th, feel free. But during this time, you can't go after the permanent guarantees. Now, where did this go amok that every commercial tenant and residential tenant in New York believes that their guarantee is no good because the press and politicians blame the press for all evils. Or it's that prophecy is kind of becoming true, but to an extent. This does not apply to residential. It only applies to commercial, and it's very limited. The economic defaults from which the guarantors are relieved of enforcement include utility expenses or taxes owed by the tenant under the lease agreement, or fees and charges relating to routine building maintenance owed by the tenant under the lease or rental agreement. As I said, the bar on enforcement is permanent. Now, the only guarantors this law protects are actual human beings, regardless of whether they are good guy guarantors or full guarantors. Very important to understand that. If the guarantor is another business entity, such as a corporation, a limited partnership, or LLC, the law does not protect you. So it's only protecting human beings. Furthermore, the law is already protecting 5 categories. If you are a guarantor and the business you're guaranteeing is not in one of these 5 categories, and this is the most important slide on this subject, then you could still go after the guarantor. And here it is. And this is the most misunderstood conception. I've read at least 10 articles where they just completely miss this. And it's just like a free-for-all. You're free from guarantors. Let freedom ring. Go after, you don't have to pay your guarantors. And if you know how many letters I've gotten from attorneys and commercial tenants telling me that they're off the hook, and then I have to send them a letter back with, here's my article on the subject. It was in Real Estate Weekly. And your establishment does not qualify because you are not, number one, a restaurant and bar banned by the governor's orders from on-premises food service. You're not a retail establishment shut down for being non-essential. You're not a gambling facility. You're not a gym, fitness center, and classes and movie theaters. And I just lost my PowerPoint for some reason. Hold on. I just lost Zoom. 1 second. Wait. Zoom seems to be on. Oh, no, I'm back. Okay. And number 5, you're not a hairdresser and other cosmetic establishment. As to all of these, the enactment protects their guarantors whether or not the business actually sustained the loss of income due to COVID. Now, we've gotten that down. Let's go into the residential tenant owes you money. What do? Housing court opened a few weeks ago. They said they're open for business. Do you file there? Now, while we could go through the wretched 4-month history of executive orders and judicial pronouncements, which it's been like, it's like playing a game of hide and go seek with the administration. I don't think that's the best analogy, but that's the best I got right now. It is best to tell you that where things are at the moment, we are writing to and leaving. It's best to tell you that where things are at the moment, we are writing to you and to leave the past in the past as much as possible. So in other words, I'm not going to go through the history, but we are going to go through where we are today. Okay. There's 2 things going on. There's a law called the Safe Harbor Law that governs housing court proceedings, and there's an executive order that governs housing court proceedings. And then there is housing court, which is following its own rules. I will say that at one point, housing court was disregarding the governor's executive order and making up its own rules. Only in New York. And then the governor saw that, came out with a new executive order challenging the administration, and the administration reacted, and we are where we are today. Okay. Okay. This is worth it. The current situation starts with two laws the legislature passed. One passed at the beginning of the crisis, giving the governor authority to temporarily amend any New York law at all on its own without legislative oversight. And the other passed only a few days ago, changing the procedures for suing in resident proceedings. First, we note that although the civil court, of which housing court is a part, is continuing to prosecute landlords for violations, it is still not accepting new cases for landlords to try to bring. As ever, landlord-tenant cases start with buying an index number. Let me explain this. To start a housing court case in today's world, they require that you go through NYSEF, NYSCEF. So you go on your computer and you buy an index number through NYSEF like you do in state Supreme Court. And you can't do it. Why? Because it's not working yet. They said it's going to be working by the end of the summer. But in the recent judicial memorandum put out by the administration, it says that you could do that right away or do that very soon. But right now it's not working. It says there's two ways of starting a housing court case, by mail or by NYSEF. And they said that you can do trials right now. However, if you can't buy an index number to start your housing court case, then how are you going to go to trial? Let me break it down. Number one, they open housing court and they close housing court. It is not a good idea to go to housing court because if you start a case in housing court, you can't because you can't buy an index number. If you have a pending case in housing court and you somehow got lucky enough to get an index number and it is pre-COVID, pre-March, pre-middle of March, then your case can proceed if there are two attorneys agreeing and you're willing to settle the case. Since that proclamation, memos have come out by the chief judges saying we can go to trial. Since then, the unions come out saying we won't be there for your trial, but that's a different story. Also, we were told that if you have two attorneys and you somehow have an ongoing case and it is not pre-COVID, we will be adjourning your case for a long time. That's literally what they said, a long time. So since there is no NYSEF in the civil court at the present time, and although its implementation has been promised to take place within the next 2 weeks, I wouldn't bet on it. And even with NYSEF in place, the way to start a case, in order for a case to run purely electronically, the tenant has to consent. But if there is no consent, the case will be on paper only, and it is expected that all paper-driven cases will take an extremely long time to process. Thus, as a practical matter, no cases can be started in the civil court except to prosecute landlords for repairs or lockouts. What does that mean? If you don't have hot water or electricity or you're locked out, you can do an emergency application and you can get in a housing court right away or repairs, and that's going to be handled immediately. However, to start a case for rent, to collect rent, it's like Alice in Wonderland's garden to go through. It's just not working right now. Now, how do we know this so well? Because we're sweating it, because we've gone through the rabbit hole and we've come out the other side. or we've looked down Joseph Conrad's abyss, the horror, and we're looking at it. And what we've learned the hard way is, if a snake bites you once, it's your fault. But if a snake bites, this is Ben Franklin, but if a snake bites you twice, it's our fault. Okay. Now, for two-attorney pending cases, the court is now beginning to work on old cases by video conference, but only if there are lawyers on both sides and only for the purpose of settling cases. There are no trials until July 27th. Now, on July 27th, they are said to setting up trials. But then we got the memo the day after this came out from the union. I've never heard of this union saying we're not going to be there because we object because things are bad out there. It was more eloquent than that. We do have partial solutions to these things. So this is what's actually going on the floor. We will get into the laws and what's supposed to be happening, but this is actually what's going on the ground, real information of our law firm of 20-something attorneys that's actually trying to prosecute cases. The good news is, not including July, the rent in Manhattan, paying is 80%. You're going to the Bronx, it's only 60%. So we're really, it's the counties that need, it's the landlords that need to pay their mortgages really desperately, that really need rent, that really need help, that really need to get into court. And that's why we're really struggling. And that's why I'm so intensely, I'm probably intense with most things, but I'm intensely having a problem here. Okay. So the state attorney general jumped in. And of all the problems in the world, the state attorney general, I'm not going to name the law firm, went after, it wasn't our firm, went after a law firm for sending out residential notices for serving rent demands, because the governor's order, this is the newest order, the old orders didn't do this, prohibits the initiation of a proceeding or enforcement of either an eviction or of any residential or commercial tenant for non-payment of rent. But the problem is, sending out a notice is not a judicial proceeding. Sending out a notice is not it's not the start of a proceeding. It's a notice. According to the Attorney General, the way they wrote their notice is scared the tenants. I don't have all the facts. They did not put out, the Attorney General only put out a press release. I don't have all the facts. I just think as practitioners, you should be aware. The settlement was literally, they're not going to send out notices anymore. That was it. Window dressing, but if the Attorney General is looking to prosecute, maybe you want to be careful in which residential tenants you're going after. Okay, here's the law. Well, this is the law that's now in existence, that's signed by the governor, and this is important to know because this is what the court should be following and not the games that's being played. On June 30th, the Tenant Safe Harbor Act was signed into law. The law prevents evictions for non-payment of rent during the COVID-19 period if a residential tenant can provide hardship. This is really good news. Why? Because it allows you, number one, this law, to start a non-payment case. It allows you to start cases in housing court, this law, by the state legislature. It allows you to go seek an eviction. It allows you to not have to do crazy affidavits. It takes away one of the affidavits that you had to do before. And it makes the COVID-19 defense and the unemployment benefits defense as a defense, as an affirmative defense that they would raise. And cases can be prosecuted, but so if you put in I'm on unemployment and I'm receiving benefits, or my business has been affected, or I've been affected by COVID-19, and you put that as an affirmative defense, then this law says for those cases, you can't be evicted. The only thing a landlord can receive is a money judgment. A money judgment can be awarded, but not an eviction. Now, that is really good news for the landlord bar, because for all the other cases, they can receive an eviction. For these cases, when someone raises affirmative defense and they win the case, all they can receive is a money judgment. Now, in reality, what happens in most landlord-tenant cases is they're going to be settled, and there's going to be stipulations, and there's supposed to be a whole bunch of pro bono attorneys that are going to be representing the tenants that come for money. So most of these cases don't go to trial anyway. What's going to be interesting is, where is the money coming from? Where it usually comes from the government. A lot of times the state government, a lot of times the federal government. However, if you're looking at the numbers like I have, the city is bankrupt. And I'm not exaggerating. The city is bankrupt. They don't have money. The state is bankrupt, and they've been literally hiding it. They don't have money. They didn't budget. They're both the city and state are bankrupt. So when you have persons that don't have enough money to pay their rent, and for many years they've been getting one-shot deals or these programs from the federal and state government, and there's no money there to get them anymore, I actually don't know where the money's coming from. Now, what the state and the city are betting on is that the federal government gives them this money. I don't know what deal is being made. I don't know if a deal is being made, but the state needs the federal government to come up with money. I'm not being political here. I'm just letting you know that I don't know how the state survives without a federal influx of federal money. Why do you need to know this when you're practicing residential law right now? Is because if you don't look at the big picture and understand why things are happening or what's going on, then it's gonna be tough for you to make future decisions, which you'll see in a second. Okay. Now, you have that law, which is good news for the landlord bar, at least semi-good news. Now there's with that law, which is the state legislature signed by the governor, we also have on July 6th, and you see how new these dates are, Executive Order 202.48 appeared. It ended most of the previous executive orders, except it continued for 30 days, stopping commercial evictions and commercial foreclosures. Now, why did it do that? Because in the safe harbor law we just discussed, it only talked about residential, and it forgot to mention commercial. On my lecture for AmTrust tomorrow on commercial, we deal with this. And it's a whole different, they have their own different set of problems there. And there's a bill pending, moving very fast to stop commercial evictions and commercial foreclosures in a state law moving forward for a long time. That's moving very fast. That if you are on the plaintiff's bar, meaning you're doing foreclosures, you probably want to get involved in that. I know our firm is actively involved in it. Okay. Number 2, affirmative defenses. A tenant would assert this as an affirmative defense. Factors to be considered include the tenant's lawful income prior to COVID-19, liquid assets, cash assistance, supplemental nutrition assist program, the New York State Disability Program, and unemployment insurance benefits under state or federal law. This is commercial property evictions. Courts may be commenced and prosecuted, and judges must award money judgments for rent due, but may not allow evictions for residential cases. We already did that. Evictions can be awarded for commercial cases. How long is the law in effect? When signing the bill, Governor Cuomo issued an approval memorandum stating that any time a region enters phase 4, the protections of the bill expire. Well, 2 days ago, there were 0 deaths in New York City. That's good news. The governor's memorandum states that the law does not allow a tenant not to pay rent unless it faces a financial hardship during COVID-19 public health emergency, and such a non-paying tenant will face any appropriate legal action. The Tenant Safe Harbor Act does not apply to commercial tenancies. Commercial eviction notices should not be prohibited by this executive order. Contradictory. Okay. So what, Adam Leitman Bell EPC, our law firm, what are we doing? This is what we're doing. I know that Housing Court is promising that everything's going to move really fast right now. But the proof is, if we can't start a new case, then how fast can it be moving? And if we're told that everything's going to be adjourned a long time, actions speak louder than words. So we have been bringing our cases, commercial and residential, in state housing court. Now, state housing court has concurrent jurisdiction with civil court. And our cases, our foreclosure cases, our commercial landlord tenant, and our residential cases have been filed and they've been going through the system. I can't promise that one day they're not going to be thrown out. But this is how we've been solving this problem. There's no mishigash, which I guess everything's said better in Yiddish, but meaning there's no chaos. And things are going smoothly. Now, I don't know where this is going to end, but for me, when I'm not given any choices, I know that this is the best choice. And the Supreme Court is working well. Now, the best court to be at is federal court. However, when we have our federal court cases are federal issues, I don't have that for real estate because the property is in state court. You know why? I don't want to spend time in this. We don't have enough time. It's only an hour. But you know why we're in state court. The property's in New York. Both the plaintiffs and defendants are in New York, and we're not in federal court. Okay. There's a moratorium on residential mortgage foreclosures. The executive order extends until August 19th, stopping residential lenders of mortgage foreclosure proceedings for non-payment. Now, July 5th or July 6th, they put out the 30-day ending. The executive order, the previous executive order on mortgage foreclosures ends August 19. So it looks like by the end of August, mortgage foreclosures should be able to, we should be back to normal business. Unless some law comes flying through as it actually is doing. Guess what? There's a law that's flying through trying to come really quickly. Now, foreclosures prior to March, or COVID period, those can be prosecuted like everything else. In reality, things are not normal in state Supreme Court for foreclosures. There are some cases that are going smoothly and some that are not. Things are not going as fast as we like them to. My foreclosure department at our law firm is doing the best they can. We are happy some of the time and unhappy other times. But what we're doing is we're doing the best we can. We're taking our punches and we're getting back up. And like life, there's ups and downs, and you're going to have bad things happen to you, and you're going to have good things, and you're going to do the best you can. And that's the way we're handling it. But the order does not prohibit foreclosures for reasons other than non-payment as well. So if you have Unless it's non-payment, you should be going, do not pass go. You could collect your $200. If you're pre-COVID, you should be on your way. After August 19th, you should be fully proceeding, unless something else gets in the way. And, you know, in order for our economy to survive, in order for this depression not to be worse than it already is becoming, we need our businesses need to know that when they sign a contract, it is going to be fulfilled. And when you get in the way of contracts and you break them, which is in violation of the contract clause, which says that no government shall interfere with a contract, you're affecting businesses from entering into them. So this is really a horrible thing for business today and in the future. Okay. And I think we just went through these, but foreclosure matters can proceed when both parties are represented by counsel for settlement purposes. These are the rules. Lenders may move for judgment of foreclosure when a property is vacant or abandoned. No motions may be made or decided at or before August 20th. Oh, wait, by the way, the code, what number are we on here? The codes for a CLE is 159, which should have been on slide 3 if you saw it. And slide 14 is 684 for your CLE, 159 and 684. And you have one more to go. Let me just see if there's any questions that came in from Amanda. And I don't see any. Okay. The moratorium through the 19th is no motions may be made or decided at or before August 20th. There'll be further directives, and the 2 forms must be filled out. One that the attorney swears that everything is true, and the other is a bilingual form, which the courts have put out. Okay, let's get into some case law. This is a federal case, which they sued the governor, and the governor won. And I'm not going to spend too much time in this case, but there is a couple of things that I thought were really important. This federal judge found that the governor that the government did not violate the contract clause, which there are United States Supreme Court cases that agree with this, but never on this reasoning. And Judge McCone, a very good judge, states, although facially absolute, the contract clause prohibition is not draconian, is not the draconian provision that its words might seem to imply, and does not trump the police power of a state to protect the general welfare of its citizens, a power which is paramount to any rights under contracts between individuals. What she's saying is that the state's police power trumps the federal government's constitution. Okay, new to me. We're living in a brand new world of, chaos. Okay, duty to keep free of COVID-19. Yes. The buildings have a duty to keep your buildings sanitary, period. And this law right here, New York Administrative Code 17-133, is a $2,000 penalty. Okay, so we went back 100 years, scarlet fever, Spanish influenza, and smallpox. The courts were law and order, going up to the Court of Appeals, to United States Supreme Court. Majestic Hotel versus Erie, you can read the you could read, it's like perfect for today. They were very strict. It was law and order, and they found for the landlords in almost every case, unless the landlords were acting badly. If the landlords tried and they were not negligent and they cleaned up and they took care of it, and in this case, in this case, you're dealing with the scarlet fever. Any questions? I don't see any. No questions. Okay. In this case, the challenge law only impaired private contracts and not those which the state is a party. The courts must accord substantial deference to the state's conclusion that its approach reasonably promotes the public purpose for which was enacted. Because the courts conclude that neither the challenge sections of the order essentially impair plaintiff's contract rights, it does not address the purpose of the order, aka this is the Appellate Division First Department. The hotel did its job. It took care of the epidemic. It did everything right. They must pay their rent. This one, Scarlet, the Scarlet Fever in 1895. There was the part that where you go to above them where they're living, they had on top of them the place where the stuff from when you go to the bathroom the pipe above would actually drop. I guess there's a hole in the pipe, and they decided for the tenant in this one because it was dangerous to life, health, and safety. So although most of the cases for law and order, if the landlord did not do a good job, they stuck it to the landlord. So and if we reviewed every case coming out of the scarlet fever, Spanish influenza, and smallpox, and it seemed back then that they just did it better. The government was better. The government had it together. The agencies had it together. They had systems, and the courts followed it. If you followed the rules, they sided with the landlord. If you didn't, they went against you. Executive Order 202.34 authorizes building owners to deny admittance only to individuals who fail to cover their nose and mouth with a mask or cloth facing covering. Restriction of any other rights or amenities will face the same test of first proving that ownership or management went beyond the powers granted by the executive law, and second, that damages occurred as a result of any proven breach of plaintiff's contractual rights or of the warranty of habitability. Executive Order 202.34 expressly directs that any owner who denies admittance to persons who fail to cover their nose and mouth with a mask or face clothing shall not be subject to a claim of violation of the covenant of quiet enjoyment. So for those clients calling you and there's a battle over those people not wearing masks, your clients have protection to deny people who are not wearing masks admittance. And that is an executive order. They have the right to deny admittance or food or entry to the building if they're not wearing masks, and that's an executive order. This is to lighten up things and sent by a friend. If you or a loved one has been refused entry by a private business for not wearing a mask and you would like to explore legal options to protect your constitutional rights, our law firm is happy to explain just how effing stupid you are. Suing to force residents to follow the rules. Now, this is going to cause a lot of lawsuits. There's really no privacy right in New York. You have privacy rights with regards to your records. You don't have them. You don't have them with regards to. There's no like privacy law. At the same time, management has to be very careful not to discriminate against someone, because if you have COVID-19, you are considered handicapped. And that is where you have to be very careful. We started a case where someone wasn't following the rules and they refused to have social distancing. We got an order to show cause. They signed a SIP that they wouldn't do it again. And we immediately stopped it. Why? Because we didn't want the residents suing the building. And what if someone did die? We don't want, is insurance will cover it, not cover it, but we stopped it in advance to protect the residents. Constructive eviction during Scarlet fever. Just like today in Majestic Hotel versus Ear, this is appellate version First Department. The language is beautiful, but for constructive eviction, the landlord has to do something wrong. And in this case, the hotel back then, which is now an apartment building, there must be possession by paramount title or acts upon the part of the landlord or those persons subject to his control, which make the occupancy so uncomfortable that the tenant is justified in removing therefrom. There was, in this case, no claim of paramount title in any other form, nor was there actual expulsion of the tenant from the premises. Neither was there an affirmative act upon the part of the landlord which required the tenant to remove. Therefore, the tenant was required to pay their full rent. The apartments were habitable. In this case, the apartments were habitable when the tenant voluntarily vacated them. When they were leased, it was clear that after the fever was discovered, the usual precautions known to science were taken to isolate the cases and prevent the spread of disease. There were about 400 persons occupying apartments under lease in the hotel at the time of the breaking out of the fever. And for the most part, if not all of these tenants, they continued to remain and occupy their inner apartments without detriment to either health or comfort. The defendants abandoned his apartments on account of the fear of the contagion to himself and family. We are therefore to see if there is sufficient to excuse the payment of rent. We know of no ground upon which the payment of rent can be successfully resisted. So back during the Scarlet fever, the court disagreed with the tenant and said, no, there's no excuse not to pay your rent. You chose not to be there. There was no reason not to. Here is a picture of the building back in 1900. Another case, same result, same reasoning, except this is smallpox. Appellate term stated we are at a loss to discover how these facts establish an eviction of the tenant or any defense, whatever, to the proceedings. The tenant was not prevented from occupying the demised premises by any act of the landlord. If you want a copy of any of these cases, LinkedIn me, email me, and we can get you whatever you want. I know Fidelity, we sent them articles on some of these subjects They're getting to you if you're having a problem, LinkedIn or email me. Even if these acts arose to the dignity of a constructive eviction, they would constitute no defense, not having been followed by an abandonment of the premises and a surrender to the landlord. Because this tenant in this case did not hand in the keys and did not surrender the premises, even if the landlord was completely wrong, the tenant's on the hook. Okay, time of the essence closings. This is one of the hottest things going on right now. Okay, these are tricky because you need to do this right. So you need Rahmanis. You need to be giving. You need to have a heart. So your notices you can't be giving 2 weeks. You need to give at least 30 days, 30, 45, 60. At the same time, there are cases whereby if the person loses all their assets and they can't close, they may be able to get out of the contract. So if you give too much notice and the person is employed at the time they signed the contract and they're no longer employed when you're doing the time of the essence closing, you may have a problem. Number one, so you don't want to give too much time during a pandemic. Number two, take into account any COVID-related circumstances that may result in your agreeing to delay the closing. Get on the phone with the other attorney. You want to hear the story. And by hearing the story, you then want to send an email documenting the phone call of what you heard, because you want to close in their defense. There are many, many defenses in the contract. For example, one of the hottest we're seeing, number one is always a mortgage contingency. Number two is when the co-op or when the cooperative took too long to approve the buyer. Well, in the newest contract, which is less than 10 years old, the co-op has to do it by a certain time. If they didn't, that's one of the ways out that people that's one of the hottest things that you're hearing here first. That people that our firm is jumping on, and so other firms. We're on both sides of this. You want to accelerate the date if financing may disappear. So if you know that they're going to not have the financing, you're going to have to give the time, but be very weary of their financing that may go away. But most importantly, understand that if you can't make a deal with this buyer, understand the new market you may be entering into, the abyss, the new depression. So if you lose this buyer, imagine the market that you're going to be selling in 6 months to a year. Now, I don't have a crystal ball, but I'm imagining that the market before March is going to be much better than the market in January. I could be wrong, but I'll bet you that it's going to be much worse in January. Therefore, you may want to give a discount to close. You may want to make that deal. But as far as the law goes, because we're getting tons of claims that there's no way a court's going to enforce the law. Look, I'm speaking to tons of judges, and they're enforcing the law. Now don't give them, bad facts make bad law, and good facts make good law. Don't give them facts that are gonna, help them make, side against you. But you want to always look like the good guy or good girl in the case. But the New York judges are ready to enforce the law, and we're quoting the appellate division, the Spanish flu, and the Scarlet fever, and everything else, and they are enforcing the law already. We're seeing it. Okay, whether the executive orders are constitutional, the contract clause. Oh, by the way, the last code is for CLA is 736. 736. Whether the executive orders are constitutional, the contract clause versus home building and loan versus Blasdell. Now, when you read the contract clause, this is the United States Constitution. It's very simple and it's really clear. It says, no state shall pass any ex post facto law or law impairing the obligation of contracts. Very clear, right? The state cannot interfere with business. Very clear to me. However, in 1933, Minnesota enacted a law that said we're going to give borrowers more time to pay their loans. It was a temporary law. Remember that word, temporary. And they went through a five-factor test. You can imagine what it is. You know, do they need it? Is there an emergency? Is it tailored to the problem? Is it narrowly tailored? And 5-4 decision in 1933, you had a Democratic majority in the court. The United States Supreme Court said that the contract clause doesn't mean what it really says it means. And they allowed this law that allows you more time to pay your mortgage back. So this is still good law today. I do not believe that this Republican court, even with Judge Roberts being a consensus builder, I don't see the court holding this up today. But remember, you're not waiting 6 years to 4 or 5 or 6 years to have Justice Roberts write an opinion on this. But fortunately for overturning cases, our New York City and New York State legislature went way beyond Blasdell. But you need to know this case because it's going to be quoted and used against you when you try holding these cases constitutional. Amazingly, in the cases that are being brought, they're not looking at the other side and recognizing there are cases that go both ways. Okay. Now, closing the courts or not allowing cases to proceed. The argument that needs to be made and needs to be brought in your motions and your affirmative defenses is the Republican form of government, besides the contract clause, besides your regular defenses.
Okay, I found this on the web for as a Republican form of government besides logical besides.
Check
it out.
Thank you, Alexa. Okay, that's a first. That's really good. Thank you. You got that right. The Republican form of government. Article 4. So the Republican form of government, I never thought in my lifetime as an attorney I'd be using this. But this was made for the Civil War. When the government shut down, the Republican form of government requires that you have a government, that the courts are working, that the executive branch is working, and all the branches of government are working. Article 4 of the United States Constitution guarantees to every state in this union a Republican form of government. Part of having a government is that the courts be working. When courts aren't working, that's when you usually wait for a dictator to come in. It just makes no sense. So when our courts are closed or you can't file a case, please assert this clause. Because at the time of this writing, new housing court cases cannot be started unless they fit into a very select group of emergencies. And as noted above, housing court has made it almost impossible to prosecute a case by putting in so many obstacles. It appears that the Republican form of government guaranteed by the Constitution has been violated by the closing of the courts and continues to be violated by the Civil Court of the City of New York, as the courts can not be closed except for a select list of emergency actions. Do we have questions? One more. Okay, so then we get a decision by a Suffolk County judge. It's called Anthe New Neocron. I can't pronounce this. You can read it. And let me read the decision. So the Suffolk County judge, Judge Hackling, agrees. He writes, the court notes in the nature of dicta that even if Executive Order 202.28 order did not include a stay of holdover proceedings, that it would be enforceable as it fails to comport with Section 29.A of the Executive Law, which requires the governor to precisely state on what statute or regulation is being suspended and limits such executive order suspension to 30 days. So the executive order says that if the governor, which he only could do for 30 days, he did it for 90 in some cases, when the governor is going to suspend the law, he needs to state what law he's suspending. He didn't do so in his latest executive order. So as far as these residential laws that he did, these executive orders, in my humble opinion, and our office's humble opinion, and in Dove Tryman of my office, one of the leading residential attorneys out there, that the executive order is unconstitutional and that we could proceed with our cases in state Supreme Court and that the ban on proceeding is unconstitutional. Now, I know this is risky. I know this is crazy. I know this is wild, but these are wild times and they call for creative solutions. And we have a case that agrees with us. But what this judge is saying is that the executive law requires the governor to precisely state what statute or regulation is being suspended, and the governor didn't do that. So this judge finds, in this case, the governor's executive order is unconstitutional. He finds everything unconstitutional. Now it's a lower court decision, and if you're in Suffolk County, you're using it for everything. We're going to use it downstate also, and we're hoping that a New York County judge follows it as well. But my view is this is the only case in this subject besides the federal court. But this is the only judge that actually took on the executive orders. The federal case only deals with the constitutionality of the contract clause versus the constitution of the contract clause. I think it's important. Requirement to mitigate damages. This is very important. Many of you are dealing with commercial tenants handing in keys, and many of you are dealing with residential tenants handing in keys. Commercials tomorrow for a different CLE, and that is wild. This tomorrow one. This is just as wild. For residential, for commercial, landlord does not have to mitigate damages. Jeffrey Metz in my office won that case in 1995. It's called Holy Properties versus Kenneth Cole. For residential, in June of 2019, the law changed. RPL 227E, a landlord has to mitigate damages. So if a residential tenant hands you the keys, you have to try to rent it out to someone else. If they surrender properly, you have to try to rent it to someone else. A lot of people don't know this law. It's a year old, literally a year and 1 month old, and you have to know this law. You have to mitigate damages if a tenant hands in the keys. By not knowing this law, you may not be able to collect the rent. We did that one. Oh, we're going backwards. Okay, very important. These are the list. I know this silly you're going to have emailed to you, or if not, contact me. LinkedIn, my email is online. You can't, this is from Dove Tryman in my office, this slide. You cannot, these are all the ways that you will be found for harassing tenants or your clients. Basically, you can't really speak to a tenant in so many ways. You basically want to be doing it yourself. Or if you are going to speak to a tenant, ask them for permission first. And these are all the ways that you could be harassing your tenant. I'm not going to go over them right now because we're limited on time. I would send this slide to your clients. And here's more. Forbidden harassment tenants continued. The privacy laws we already went over. And let's open this up for questions. Amanda, do I have questions somewhere? Because I have a lot of emails here, but I don't know which are yours.
Hey, Adam. In the Q&A section at the bottom, it looks like we have about 16 questions. I'm not sure if any of them were covered throughout the presentation.
Where's the Q&A section? I don't know how to get there.
It should be at the very bottom of your screen. You should see participants, Q&A,
Let me move this.
chat.
Let me move this here.
Sure.
It's very bottom.
Yeah, it should have a little red pop-up with the number 16. That's about how many questions we have open that were unanswered.
Let me pull out of this. Maybe get out of this. Wait. It's on top. Got it. I see it. Okay. Let me read those. I'm clicking on it, but nothing's happening. Hold on. Let me. How do I? I'm clicking on it. Nothing's happening.
Maybe stop sharing your screen.
Okay. Stop sharing
It might
screen. Okay. I see him now. Okay. Okay, let's do them. Number one, is there a legal definition of COVID-related hardship? There is not. That's a fantastic question, Greg. There is no legal definition, and what we're doing is we are asking when we serve process, we're asking the tenant at several different times when we serve each paper, and we're putting in our papers certain language so we can bring out of them early on, not when we get to court and they have an attorney, what the problem is or what the COVID-related hardship may be, so we don't have to do it then. So there is no definition, and that's probably going to have to be litigated, but it's a great question that I like that it's not defined, because it's going to give us a lot of leeway as the months go by and the economy gets worse and worse, and businesses are really going to need help. But there is no definition. Great question. Next, New York City guarantee law question. Can you sue a New York City resident who is a guarantor of a commercial lease outside of New York City, but within New York State, in courts outside of New York City, but within New York State? What does that say? One more time. Anonymous attendee. Well, welcome, anonymous attendee. Can you sue a New York City resident who is a guarantor of a commercial lease? Okay, New York City resident. But within New York State, in courts outside of New York City. So I'm going to assuming, I can't assume anything, but in your question, if the guarantor falls under the 5 categories where they cannot be sued, you can't sue them anywhere. If they don't fall under the 5 categories, you could sue them anywhere. Can you sue a New York City resident who is a guarantor of a commercial lease outside of New York City? Yes, you could sue them outside of New York City. That answers that, I hope. Jeffrey, what is the status of commencing? Oh, the last code is 736. I hope I said that. What is the status of completing holdover proceeding in Nassau County, Suffolk District Courts, and the issuance of a warrant? It's the same. Nassau and Suffolk County have not changed their holdover proceedings. However, they are abiding by the Safe Tenant Harbor Act. So the same rules apply with the affirmative defense under the tenant's affirmative defenses. So it's going to be the same rules as New York City, because it's a state law of the Tenant Safe Harbor Act, and everything else should be the same. We understand that Suffolk County is doing much better than Nassau County with the court system, and Nassau County is learning its way. But if you're having a problem, email me or LinkedIn me. But right now, you guys should be trying to move ahead, and all you're worried about is that affirmative defense. Shari, will you be addressing the district courts on Long Island? Okay, I just did that. I thought that Nassau County is accepting new petitions by mail. Yes, Nassau County is accepting new petitions by mail. They have been accepting new petitions by mail. How many clerks are in Nassau County? I mean, I don't know about your clients, but mail is too slow for my clients. You may want to have someone, or do it yourself, bring them down in person and see if you can, you want to buy that index number. And what is it, 3 or 4 clerks? 2 in Nassau County, 3 or 4 in Manhattan? And wait till you see the pile that's lined up. So yes, they're accepting it by mail. Do not do it by mail. Bring them down. Wear a mask and gloves, face shield, but try to do it in person. If that can't happen, then put them in mail, but you may be waiting a couple months. I would not do anything by mail, Roberta. Shari, would you counsel your clients to send the late notice that is sent out on the 6th day? You can't send out late notices right now. You can't send out late notices. As soon as you can send out late notices, you're going to itemize them. You're going to have a separate notice for late notice. And then at that point, when you can collect your security again, you're going to have a form once that you're going to have the notice of replenishment form that follows the law to request that they replenish them, but make sure it follows the law. As far as the late notice, you're going to send them once the law has expired. You're going to itemize the late fees of the road, make it really formal, because you're going to sue on it. So you want to make sure you itemize it and send it nice. Do not do it on the 6th day. You want to give a grace period. You got to look good to the courts. You don't look like an animal. You want to make sure you look good for the courts. Okay. Well, Adam be discussing the Emergency Rent Relief Act of 2020, particularly has DHCR application forms or lists of subgrantees be distributing vouchers to landlords? If so, well, that's a loaded question. Okay, number one, the DHCR still has not put out the application forms, which they just put out 2 days ago, the memo that they're working on them. We've been waiting on DHCR for a long time on a lot of things. They were supposed to put out some rules for the 2019, June 2019 laws, which we haven't gotten. I don't know when they're going to do that. The Emergency Rent Relief Act, yeah, we covered that. Okay. Stephen, are you filing in Supreme Court electronically or in person? We are filing electronically. Supreme Court is working flawlessly. The electronic system is working great, and it's go. You could file electronically. It's going very well. We have not had anything rejected in the Supreme Court. We may later on, but right now we haven't. And as a result of this lecture, we may have some problems. But right now, the last lecture I gave, there was a few judges on, but we didn't have any problems with that. But right now, everything's a go, Stephen. Jill, if a free rent, non-regulated lease was signed before the HSTPA, that is the law from June 2019 that changed every rent-regulated owner's world, was enacted, but a renewal is exercised this month. Does the landlord have to abide by the terms of the HSPTA? Yes. And return extra security funds and rent overcharge? Okay, let me redo the question for you. If free rent lease was signed before the HSPA was enacted, but a renewal is exercised this month, but you basically, Jill's asking, Jill, the law says that you can only take 1 month security, but prior to June 2019, her client took more than 1 month. She's got, under the new lease, she's got to return anything above 1 month, because anything over 1 month under the new lease post June 2019 will be treble damages her client would owe. So she needs to return anything above 1 month post June 2019. That is the answer. And return the extra security deposit funds. Yes, you must return them. And rent overcharge. No, you don't have a rent overcharge if on the date, as long as, if you signed a lease prior to June 2019, you're okay for that year. It's only on the new lease that you'd have to send the money back. Because as long as the lease started, and this is the Regina decision, it clarified this for you. As long as the lease started before June 2019, you're good for the year. It's a new lease that you can only take 1 month security. Okay. Greg, is there a legal definition of COVID-related hardship? No, there isn't. Not yet. There will be decisions coming out soon, I know, because we filed motions. Roberta, would a face shield replace a mask? Yes, face shield is good. If anyone doesn't let you in because of a face shield, actually, if a face shield doesn't cover your face, I think that there'd be a problem. I'm not a health expert. My view is if your nose, Donald Trump just had this problem. If the mask doesn't cover your nose and your mouth, you're gonna have a problem. If the face shield does that, I think you're okay. I would need to see it. I'm just an expert in real estate law, but I'm happy to give you an opinion if you send me a picture. Stephen Gordon, how are you handling holdovers? I think we hit that. Okay. We are filing holdovers in state Supreme Court because housing court is broken. Eric, what about the term in paragraph 8 of the standard residential contract, which provides that a buyer takes on the risk of a change in circumstances after obtaining a mortgage? Yes, that's what we discussed. That is what I'm most worried about. That's why I don't think you could give them 8 months. My view is you have Rahmanis, meaning charity. You give them 30 days. They need 45, you give them that too. But you don't give them 6 months, because I'm extremely worried about the change of circumstances, that they lose their job and all of a sudden they can get out of the contract. We are dealing with this hands-on, which I can't give too much away because I'm in the throes of litigation on this. But Eric, you're right on. You got to be worried about that clause. This is on someone trying to get out of the contract. Everyone that closed can get a better deal if they bought now. So everybody wants out of their contracts. So Eric, you want to worry about that clause. You need to give them enough time that the court's going to allow you to sue for your deposit and keep the deposit. But you give them too much time, they're gonna abuse you and get out of the contract. So great job, Eric, being very worried about that. Anonymous attendee, is there anything he could touch on briefly? I guess that's me. About town and village justice courts not taking landlord-tenant cases. I did do that. I gave you weapons and arguments and motions to make based on the Constitution, based on state law, based on local law in this PowerPoint, that you should take putting emotions, these arguments, from the Republican clause to the contract clause to the Justice Hackling decision, forcing these courts to take your cases. If they don't take these cases, you need to make the motion, have it denied, and if they refuse to even rule on it, you're going to need to do an Article 78 and take it up to a higher court and then you're going to have to appeal them. But you're going to have to be aggressive. And if you're having trouble with that, I'm happy to speak to you about it. My email is on Google, and I am on LinkedIn. It's alb@alblawfirm.com. Is this CLE 1.5 credits? I don't know. I just speak for free. You know, that's what I do. I don't know how many credits. Amanda, do you know how many credits?
This is a 1 credit CLA.
1 credit. I'm sorry. I'm just, you know, I'm not Bono or Jay-Z or Beyonce or, you know, any, you know, just a humble servant. You know, maybe one day I'll work up to 1.5. But actually, we're doing a lot of time. Maybe we could get 1.5. Maybe we should appeal that. Let's fight, Republican Club. Okay. Does mitigation of damages under the HSTPA, that I hate pronouncing what that stands for because it doesn't. It's like an irony because it's, you know, it doesn't mean what it stands for. Apply to commercial leases? No, it doesn't. The HSTPA has nothing to do with commercial leases, and you do not have to mitigate damages under commercial leases. Holy Properties versus Kenneth Cole, 1995. Jeffrey Metz of Adeline Bell APC. It's a selfish plug. I apologize, but we're very proud of Jeffrey for winning that case, and it's still good law. You do not have to mitigate damages for commercial in New York State. Most other states you have to, but not under New York yet. It's the one thing the communists have not overturned yet. Anonymous attendee again. Can you send, or it could be a different anonymous attendee, can you send the information regarding the Morales CLE that you referenced? It's AmTrust. It's Annabelle, can you post on LinkedIn tomorrow's CLE, please? Go to my LinkedIn, Adam Leitman Bailey. My name is behind me. See, there you go. Okay. It'll be on LinkedIn in a minute. Lewis. Hi, Lewis. I know you. Do you agree that late fees can be charged by an HOA and condo boards since there is no landlord-tenant relationship? If you are a co-op, you are a tenant shareholder, you cannot charge late fees. There is a landlord-tenant relationship. If you're a condo, feel free. Condo is not a tenant. A co-op is. Go for it. But remember, it cannot be a penalty. Liquidated damages. It cannot be a penalty. It only can be a reasonable relationship to the damage that it caused. And I wrote an article on that. It's on my website, alblawfirm.com. Steve Gordon, have you successfully filed any new cases in housing court since June 22nd? No, we are not filing in housing court. You can't. You can't. We're filing in state Supreme Court, Stephen. Robert, are rent demands facially void when they mention itemized late fees? No. Great question. I don't know the answer. This is assuming that the late fees are not itemized in a non-payment position. I forget being facially void. I wouldn't do it because you're looking at bad stuff, trouble damages, etc. I don't know what bad things can happen in the night for putting on late fees. I would send a new rent demand. Don't mess around with please don't mess around with late fees until withdraw that rent demand. Don't mess around with that until you're allowed to send late fees. You're playing. They may kick the case out. Don't mess around with that. Redo that rent demand. Look, it takes 5. Look, you can't. You're filing a housing court anyway. Nothing's going to happen for months. You might as well start. You may as well get everything perfect and do it right. Better to do it right and apologize to your client and say, "Hey, I'm going to do the right thing," than go through a year mess or more and come back and have to do it over. Anonymous again, or another anonymous. A lot of anonymous is really a lot of anonymous out there. Regarding guarantees, I want to make sure that normal rental payments for commercial tenant guarantees are not enforceable during the pandemic. I want to make sure that normal rental payments for commercial tenant guarantees are not enforceable. I want to make sure normal rental payments for commercial tenant guarantees. It depends on whether it's one of the 5 categories. Commercial tenant guarantees are only non-enforceable from March to September 30th, and if they're one of the 5 categories that are accepted from, that are permanently barred from collection. So please either go back and read the slides or read my Real Estate Weekly article, which Fidelity is sending you or has sent you, or we can send you. We have a newsletter going out any day. You're welcome to join our newsletter list. Just let us know. Some of you on this list already get it. It goes by mail and email. Can you provide the language you include in your process skin the tenant about air COVID related problems? Well, we provide I can't provide it right now because I don't have it in front of me, but I'm happy. We're always happy to share. Our law firm believes that part of our duty as attorneys is we're lawyers. So we help other lawyers. We're happy to share that. Stuart, Adam, nice job. Oh, wow, a compliment. Thank you. It's nice, so nice. In determining whether a tenant has been COVID affected, how much weight do you give the fact that the tenant was in arrears pre-March or has a history of prior non-payments? Oh, I'm gonna be all over that. I'm gonna be showing the judge, this tenant has shown no doctor bills, has shown nothing different post March 15th as it has pre-March 15th. And I've included the last 10 years of late payments, which is the exact same as they're doing now. In fact, they're in a business that, based on the recent economic survey, shows that has been booming. In fact, we took a video of their kitchen, and they were only able to serve 30 people in a restaurant, only seat 30 in a restaurant pre-COVID, and now they're serving hundreds. They've hired 10 extra delivery people, and their orders based on the receipts received from the delivery service shows that they're feeding 150 a night. I believe that there must be a mistake in their filing. Thank you. Please give us a warrant of eviction. Eric, I was advised by the clerk of Nassau County District Court not to mail. Yes, do not mail in Nassau County. But yes, I agree with you, Eric. Not to mail and process as long as it will be moved quickly and you'll get a long day. Yes. Like, yeah, Eric's basically saying you're going to wait forever if you mail anything to Nassau County. You're absolutely right, Eric. But if you're going against me in a case in Nassau County, please do mail. Can you send a statement of rent owed on the first of the month showing back rent? I need more information, Anonymous, because that's a loaded question. Next, how can you start a new petition without sending a late notice first? No, you're going to need to send all arrears, but don't put late fees unless you're going to have all of the arrears in it, but you can't have late fees in it. Sean, what are your thoughts on a 30-day notice to vacate required by the CARES Act? Does it need to be separate from the 14-day rent demand? You need to follow the same notices you were following pre-COVID. You can't have new rules. You got to follow the CARES Act, everything in it. We're following everything we did prior to March, the same way you always did it, and the new things that have come in, and we understand we need to be perfect now because it's hard enough. So we're having extra eyes checking it. How are you handling New York City holdover case filings? We're going to state Supreme Court. Next. How can we serve notices to quit and petitions post FC holdover evictions when the marshal process servers are standing down? Marshals and process servers are not standing down. That's not true. Our marshal and process servers are working full time. I'm not referring our process server, not because I'm selfish, but he works for us full time because we're one of the larger shops in town because we have 50 people. But no, there are process servers that are working. You may need to get a new process server, but process servers and marshals are working. Post FC evictions are precluded from being filed electronically. The lecture covers that. You got to be aggressive, and you may have to file motions. You're going to have to look in this environment. You're going to have to challenge things creatively like you've never done before. This is, you as attorneys are being challenged like you've never been challenged before. You're going to have to be aggressive and creative, and you're going to have to challenge the man and the woman. And you're challenging the administration. Your government is acting unconstitutionally and without the power. And that's what we attorneys are not made to take orders. We're made to act creatively and fight for our clients. And that's what we're being paid to do. And if you're not going to be creative and do it now, and I've given you a lecture full of ways to do it, then then this is not a time for you. I don't mean to be insulting. Next, meaning can a landlord send it to the tenant without referencing any late charges? You cannot reference late charges. Yes. Are you sending out rent demands on commercial tenants who voluntarily vacated and turned over keys? That's tomorrow's lecture. You mentioned that you should not send out late notices to filling your eviction notice actions for holdovers. Wait, hold on. You mentioned you should not send out late notices, but then how can you start a petition? No, you send out late notices. You can't put in late fees. Yes, we're sending out notices. How are you serving notices to quit in Supreme prior to filing? No, we're following all the normal rules of a holdover. We're following everything we have always done. So should you. What do you think of the Hampton seasonal leases where tenants make prepayments for the entire season by entering 3 separate consecutive monthly prepaid leases? That is ridiculous. It's not going to hold up in court. A rose by any other name, as well as a suite. You can only take 1 month security by doing 3 monthly prepaid leases for the same space. All the tenant has to do is say, I've been living there nonstop for the entire year or the entire summer. And all I did was sign, I have a document that's for them to get around the law for 3 different months. So now I paid everything. I've moved out. I want my treble damages. I want my rent back times 3. I don't see how, if I'm representing him, how I could lose that case. It's a slam dunk. That is a fraud. That's fraud by any other name is fraud. Rose by any other name sells a suite. There's no way they're winning that case. Also missed the third code. I don't know what that means. Oh, the third code, 736. Third code, 736. Sorry about that. The duty to mitigate exists in residential leases and not at all for commercial. Correct. Residential, you have to mitigate based on the June 2019 law. Commercial, you do not. Commercial, the site is Holy Properties Earth is Kenneth Cole. And would a landlord establish that they did mitigate damages? How would a landlord establish it? Advertise, find a broker, advertise, post, do everything you can to try to rent the place and document everything. If a tree falls in the forest and no one heard it fall, in New York, it didn't fall. You got to document everything and really try to rent it out. For residential, commercial, you don't have to. What other creative ways, I think we're up to you guys getting 2 credits now. What other creative ways can a buyer of a residential co-op or condo claim that they have a right to cancel a contract? That's another lecture. Someone should have me do that lecture because that is in 2010, Congress was nice enough to pass a law in my name. The Interstate Land Sales Full Disclosure Act. Is there anything in the boilerplate contract such as access to unit? You're not going to get out of the contract based on access to unit. That's not going to work there. And I think we're done with questions. That's the last question.
Yep, looks like that's our next question.
Okay. Thank you so much for the honor and opportunity to speak to you. This is history. This is historical, and may destiny be on your side. Thank you very much.
Thanks, Adam.